My Lord, and my lady, I suggested at the end of the, before the adjournment, that I would give reference to the transcript of Deputy Judge Simpson.
Ah, yes.
Yes. Now, a copy of that is not in the bundle, but it has been forwarded to your clerk, and I understand it has been passed on.
Yes.
For reference, the transcript of pages 14, bottom of 14 through to 16, show the discussion between the parties, and that Mr. Glassborough did not give evidence on this point, and it was simply dealt with on the papers. I wonder if your lordships want, and your lordship wish, an opportunity to look at that.
Would you say towards the bottom of 15?
Bottom of page 14,
Right.
which is from my submissions. So from Mr. Mantle, where he states, well, I mean, sir, my point was not saying let's not do it. My point was saying let's do it on submission alone. From that point onwards.
Right. Thank you.
Well, Lords and my lady, the inevitable consequence of Mr. Glassborough's evidence not being submitted on this point is that there was no evidence as to the source of any of the information contained within the Reconstitution. Obviously, the defendant denied receiving in our defence, so it's clearly for the claimant to prove their case.
Yes.
In my submission, the evidence should have been from the original creditor, MBNA, citing their sources, how they came to create these documents, and the allowance of cross-examination. Of course, that didn't occur.
Yes. Thank you very much.
If I may just conclude by drawing your Lordship's attention to paragraph 13 of my skeleton argument, and beg your indulgence there. Simply a reference there to the European Court's decision in the case of Backhouse. And I would just invite your Lordships just to read paragraph 13. And if required, I can take your Lordships and your Ladyship to
Sorry, can you remind me of the paragraph of your skeleton?
It's paragraph 13, my Lord. 1-3, yes.
Yes, well, the Consumer Credit Act does just that, doesn't it?
In what sense, my Lord?
Well, the claimant in a consumer credit case must be required to prove to the court certain obligations have been fulfilled. The diligent creditor must be aware of the need to gather and retain evidence that his obligations have been fulfilled. The first part of it, you say, is to be found in the regulations, and the second part of it is, you say, supports your case.
Does the 1974 Act implement a directive?
No, it does not. It does not. The Consumer Credit Act was the first of its kind, pretty much around the world.
So why is an opinion of an Advocate General in the decision of the ECJ relevant?
It's because of the process that the consumer has to go through and the creditor has to go through in establishing their compliance with various regulations and what they have to prove. But I appreciate that it's not.
Well, sorry, no, it's just as a matter of jurisdiction. Why is what the CJU has to say relevant if the 74 Act doesn't implement a directive?
Parts of that directive were incorporated into the 1974 Act.
Oh, I see. Right.
Yes.
Okay. Well,
But
that's
to be clear, the question before the court and that wasn't about default, etc. It's about provision of information prior to signing into an agreement. So it's not exactly on point because it doesn't deal with default notices.
And also it's an opinion of an Advocate General rather than a decision of the court.
There's the decision of the court and then the opinion of the Advocate General in support. So they're both included at tab 6 and tab 7. So it's paragraphs 27 and 28 of the ECJ case.
So does that say the same as the citation from the opinion of the Advocate General?
What that says, milady, is at tab 8, and it's for reference. It's at page 81 of the authorities bundle. It's page 81 of the bundle, paragraphs 27 and 28, which have been highlighted there.
This is all about evidence of that you've complied with your obligations to provide information and explanation. So it's a slightly different point.
It is, my lady. And that the point was considered, as I set out in my skeleton argument, in MFS Portfolio Limited. But I suspect it doesn't take us any further than the point that the basic principle that the claimant must prove their case.
Well, we don't need the CJU to tell us that, do we?
You're quite right, my lady. Unless I can be of any further assistance.
Thank you very much, Mr. Brennan-Banks. Mr. Jones.
Give me disentangle myself again. A few preliminary points, if I may. You just heard, you've just received the transcript, I think, of the prior to the hearing before DDJ Simpson, and it's quite obvious that it was agreed in terms that the claimant's case would be tried on the documents before the court, and it was actually expressly agreed to be so. Mr. Glasborough, the witness statement, but that seems to have been agreed to be put on one side, and it was expressly agreed, page 15, my friend Mr. Brennan-Banks says, because there's been some debate about whether Mr. Goodinson should be required to give evidence. And he says, we're happy to offer no evidence, simply test the claimant's case on the documents before the court. So that's the first one. Secondly, learned friend seems to be very troubled about carte blanche and floodgates and the rest of it. But I say that district judges are astute to the issues in these cases. They're tried up and down the country. They're all fact specific. And really it's incorrect to say that judges aren't capable of resolving the factual disputes which are deployed before. I mean, that's so obvious.
It would have been open to the Deputy District Judge in this case to say, I'm not satisfied that any valid notice was sent.
Absolutely.
Even though Mr. Goodinson hasn't given evidence, but just the claimants have not satisfied me that they sent valid notice. This line of code is all very well. A reconstituted document, I find, is what should have happened, but I'm not satisfied. Absolutely. It did happen. Case dismissed.
Absolutely. Completely open to the district judge. And he went through, obviously, he in great detail, because I'm sure you've all read the judgment. I'm not going to take you to it again. Well, I might in a moment. But he went through in great detail all the archives and so on, all the references, and he linked it in to the notice of default, which had been produced. And I'll come on to that in a moment. But he went through it all in great detail, and learned friend was there to put his arguments forward. This whole question of reconstituted is not a change of case. This is how the DGJ viewed it. He knew what he was doing. He knew that's what he had to do. He went through the, you remember the credit card statements, and then he went to the notice of default. Then he went to the archive logs, and he was satisfied that he could correlate the two together. And my learned friend addressed him on that. It can't have been a big surprise that this was the exercise being carried out. The documents had been disclosed, the archive logs and so on had been disclosed before then. Learned friend had, according to the judgment, gone through trying to find a particular reference to an individual whose code appeared. But, so there was no surprise about the exercise that took place. It was effectively the agreed way in which the dispute was going to be resolved. And Lord Milady, I mean, had it really been the case at the end of it that reconstitution was the big problem, reconstitution was procedurally unfair, then that should have been appealed. And it was not. It was never said that this was an inappropriate way of carrying out the exercise. It was always simply that the DGJ should not have drawn the inferences he did. And the same in front of Judge Clarke. Again, there wasn't an attack on the whole basis of reconstitution. That wasn't it at all. It's emerged today as a sort of sidewind of Millennium Friend's case, which, if I may say so, he's deployed most skillfully before you in terms of what should be the complaint. But at the end of the day, he didn't appeal it at the time, and we're going to have a look at the moment in terms of the judgment and how that came about.
What do you say about the list of documents, Mr.
Yes,
James?
well,
I'm not very impressed by this.
The list of documents, I'm not impressed by either, man. I'm being entirely blunt. It should have said reconstituted copy. It's page 157 of the supplementary bundle. Item 26. Well, I accept straight away. It should have said something different. I mean, it should have been. But that said, once the disclosure had taken place, it was perfectly obvious what the exercise was going to be and what the exercise indeed was before the learned Deputy District Judge. So, yes, it would have been better, and I accept that straight away, had it said, this is a reconstituted document. But the actual document itself was produced, the notice of default was produced, and then there was the exercise, which I've said. There was no suggestion that this was an inappropriate way of proceeding, no call for the original document, no request from Mr. Glasgow to give evidence, and no appeal against the way in which the learned judge decided, as he did, on the evidence before him, on the agreed basis to deal with it on the documents, that it was reconstituted. So yes, of course, I mean, I'm sure those behind me are not squirming, but of course they wish that this is one of many cases they deal with. Of course they wish that they had put something slightly different, reconstituted in documents, but there was nobody was taken by surprise, nobody was misled once one in front of the DGJ.
How did the Deputy District Judge reach the conclusion that it was a reconstituted document? Well, it's been pointed out there's a date point and a regulator point.
Yes.
Those, I see it, were probably a patent from the bit of evidence that wasn't before the judge.
Well, yes. Well, somebody must have told him that the notice of default was not contemporaneous because of the name of the company.
It wasn't an evidential conclusion. It was something that was common ground. It seems.
Seems, yes, but it seems to have emerged, may I say, without dispute, and something he picked up on, and that seems to have come out during the course of the case. No evidence on it, but that's the problem, of course, when you get no evidence other than the documents. Similar there. Can I just say also, by way of preliminary remarks, that there's been no authority by way of decided cases or regulation, statutory authority to say that you cannot have, for these purposes, a reconstituted notice of default. There's nothing of that sort at all. We've had a trip round what has to happen when there is a duty to provide information and the various regulations which apply, but there's nothing to indicate that a notice of default has to be, obviously has to comply with sections 87 and 88, but nowhere is it any suggestion that you cannot have a reconstituted copy. So at the end of the day, what we say is that this narrows down to the actual hearing itself, where Mr. Glasbrough, it's agreed, does not give evidence. There's documents only, no objection to the way the actual trial proceeded, no appeal against the whole reconstitution point. And if it was so important, so urgent, such a desperately important point to the appellants, one would have thought the first thing would have been in an appeal to Honourable Judge Clarke, saying that this is just unfair, it's an unfair process. But there's nothing of that sort at all. So at the end of the day, what this can be said to narrow down to, it depends on what view Lords and Milady take on this. It really comes down to the very narrow point as to whether the district judge, reviewing the evidence on the agreed basis, on the documents alone, was entitled to draw the inference he did, having regard to notice of default, and the logs and so on that he had available. He'd obviously looked at them before. He'd obviously been through them all. He'd obviously satisfied himself that this was appropriate. There was every opportunity to dissuade him from that, but he was not dissuaded from it, and he drew the conclusion he did. And on that, he drew the conclusion he did. And on that basis, we say, well, that's a factual conclusion which we would respectfully say he was entitled to draw on the evidence before him, and as such, this appeal should not succeed. And that was certainly the way Honourable Judge Clarke viewed the matters when matters were ventilated before her. Can I just refer to one point on the learned judge's... can I just refer you to the transcript one moment? DDJ's judgment, paragraph 23, which I'll simply read it, because what's said there had been referred to the case of Doyle, which you've been referred to today, which of course was related to limitation. And the question of at what stage, when did your cause of action accrue? Was it the date of the debt? Was it the date of the notice of default? And this court decided that in fact it's the notice of default, not the date of the debt. But that was the Doyle case. And paragraph 23, though, the learned DDJ says, I mean, referred to section 88, prescribed form of the notice. I had no issues raised today in relation to the prescribed form of the notice dated 33rd of December, although I think there are issues raised in terms of the prescribed form in subsequent default notice or purported default notices. So there was no issue raised in terms of the actual content. So what seems to have been in play was whether or not he could be satisfied within the generous ambit afforded to him that the notice of default had been produced in the form in which he saw it, even though it was, as we're calling it, a reconstituted copy. But no question that it was the exercise was open, was clear, and was, if my learned friend really had been troubled about it, could have appealed it. And of course, Her Honour Judge Clarke took the same view, and as was observed earlier, reconstituted was an expression that was was used by the DDJ. It was used by Her Honour Judge Clarke. She said, we looked at it earlier. She said this is a reconstituted document. I think my Lord Justice Warby referred to paragraph 4 of her judgment, where she actually said in terms, it wasn't a photocopy. Everybody knew exactly what it was. There's no doubt at all about it in terms of the document that was before her. And so, although it's been suggested we've had a change of case, we just said that's just not right. Absolutely not right from the off. I appreciate the list of documents. I appreciate that it should have been phrased differently, but from the hearing onwards, from the agreed hearing onwards, from the agreed way in which the issue should be determined onwards, it was perfectly obvious what was in play. It was a reconstituted document, and that's why all the schedules had to be looked at. Why else would they be?
You would accept then, I think, that some criticism could be made of the way it was put in the particulars of claim.
It doesn't actually say reconstituted.
But it doesn't say reconstituted.
No, it doesn't.
That's part of the argument against you, that
Yes.
the term reconstituted was deployed at a later stage.
It was in a
So it's not an unknown term, but the document was described as a copy.
I think it was in the context of the reconstituted. I think of the reconstituted agreement. I
Yes.
think that's what it was referring to in terms of the reply, when there'd been an issue raised as to form the reply. So, best case, starting afresh. Yes, list of documents be phrased slightly differently. Yes, best case, particulars of claim would actually say in terms reconstituted. But standing here now, looking to see, because after all, at the end of the day, what we're looking at is the decision of the DDJ and then Her Honour Judge Clarke. What was agreed as an exercise was obvious, and with no obvious attempt to say this is unfair, it's inappropriate, I can't have an adjournment, we want to call somebody from MBNA, and nothing of that sort at all. We want to call from Mr. Glasbro's, nothing of that sort at all. I didn't really want to trouble you with Carey, because Carey deals with a very different set of circumstances. Carey deals with a case where you've got a duty to provide a document, and yes, you can in those circumstances reconstitute. Obviously it has to be fair, it has to be drawn from appropriate sources, but I don't think it's really going to assist the court in deciding whether or not, in this case, the learned DDJ was entitled to conclude as he did on the material before him that there was a proper notice of default.
Is that where the term reconstituted comes from, is it? Judge Waxman, as he then was? Or does it go back further?
I'm not sure how far it goes back. I must say, I'm sorry, I haven't looked up the history of the expression reconstituted. Well, sort of shorthand here, I'm not sure, but it's obvious what it means in this context.
Yes.
Maybe it can, of course, mean different things in different contexts. But here, I think it's pretty obvious. Well, I hope it's pretty obvious what it means, and it's certainly how the DDJ approached it when he was looking at it to see whether or not he could be satisfied on the materials that the notice had been produced at all, and so he looks at the underlying well, I say primary sources of evidence. I hesitate to take you. You've seen the information system and the archive comments records. I don't think it's really going to help you at this stage if I take you to those. What we say is that the DDJ properly went to those records. There's been no suggestion today that he got that wrong in terms of his references, and so I'm not sure it's going to help you for me to take you to them. I'm very happy to do so. I've got the references if you'd like me to do so, but I don't think that's really going to help you. I'll move on then to Her Honour Judge Clarke, who is addressed at length. As you know, there were four grounds of appeal. She rejected 3 on paper, then there was the oral representations, and we looked at the transcript earlier of her conclusions on that. And at the end of it, and of course we've seen her judgment, it's in the core bundle. She concludes, we looked at it earlier, she concludes at the end of her judgment that the conclusions of the Deputy District Judge were open to him to make, and she was not persuaded otherwise. Obviously Mr. Brennan Banks, his usual forceful way, would have sought to persuade her otherwise, but she concludes, and it's page 44 to 45 of the core bundle, that the conclusion drawn by the DDJ was within the test is whether his decision to draw that inference was in all the circumstances within the ambit within which reasonable disagreement is possible, and I'm satisfied it was. It was a decision which he was entitled to make. Can I just move on a little to this whole question of the best evidence rule? Obviously, you've been taken to the main authority, Court of Appeal Authority, Masquerade Music against Springsteen. Would you like me to take you back to it?
I don't think so. Paragraph 45 is still good law.
Yeah.
It doesn't strike me as very controversial.
Yes, exactly, yes. I mean, obviously, best evidence is what you want to have if you possibly can, and I'm sure PRA, if they were here today, would be jumping up and down saying they wish they'd had the actual notice, of course. But if you don't have that, then it's a question of, as we say, for the judge, as a matter of judicial discretion, to look to see whether or not the secondary evidence is enough in the light of all the circumstances, what weight should be attached to that evidence. And we make reference also, that's the fundamental decision, of course, is Masquerade Music and Springsteen. And then it's been applied, and we make reference to it in the Promontoria Oak case. That's just an example of it being applied by Mr. Justice Marcus Smith. But there's no dispute, of course, and no disagreement in terms of the actual test which applies from the Masquerade Music case. So I'm happy to take you to Promontoria. We've set it out in our skeleton, if that's of any assistance to the court. It's at paragraph 29 of our skeleton, evaluating secondary evidence and particular factors. But again, really, this comes back to evaluating the evidence and assessing what weight one attaches to the evidence, which, if I may respectfully say so, is obviously the duty of the judge at first instance, one which we say he carried out here. Other people might reach a different conclusion, but as Her Honour Judge Clarke said, we would argue it was within the bounds of his discretion, such that it should not be. Well, it is open to challenge, but we say it effectively was the decision he made and should not be gone behind. So well, I'm entirely in your hands whether you'd like me to take you to Promontoria Oak. It's merely an example of how the rule can work in practice. In that case, it was, I don't know if you're familiar with it, in fact, it was a case where there'd been heavily redacted assignments, and there was an issue as to what the form of the documentation was. And obviously the best evidence would be that the unredacted version, but in the circumstance it wasn't necessary to have that. But as I'm not taking you to it, but I only want to take you to it if it's going to be of assistance.
Well, it's really paragraph 46 that you're relying on, which is the synthesis.
Sorry, 46. Page
276 of the bundle, I think. where the judge says, this is Mr. Justice Marcus Smith, the best evidence rule is simply a common sense guide to the exercise of a judicial discretion as to whether or not to admit secondary evidence, and if so, what weight to attach to it. And goes on to identify a list of factors that the judge might want to bear in mind.
Absolutely right. Absolutely. In the exercise of judicial discretion, it's for him. It's for him to weigh the evidence.
Well, yes, I think the discretion is to whether to admit it.
Yes, you're absolutely
And the next exercise that you have is one of judgment.
What weight you attach to it. Absolutely right. So, my lords, lady, I don't want to truncate my submissions, but I hope they're tightly drawn, and I hope I've responded to the main gravamen of what's being said against us. But we say, at the end of the day, coming back to the issue in play, the judge was entitled to draw the inferences, which he did. It was a paper exercise by agreement. He did it. No appeal against reconstitution. This isn't going to open any sort of floodgates and enable lenders to ignore their responsibilities. District judges and others will be well aware of the need for lenders to prove their case. Of course they are. And so on that basis, we say that the horrors which seem to be contemplated by my learned friend just simply don't exist. Can I help you further?
Thank you very much, Mr. James. Mr. Brennan-Banks, no need to repeat anything, but anything to which you wish to respond, which you feel you didn't make adequately this morning.
Thank you, my lord. Yes, three simple replies to what my learned friend has just said. The first is in relation to my learned friend's submissions that we provided no authority that reconstitution is not allowed elsewhere. Now, the case of Carey only allows reconstitution under those specific sections of the Consumer Credit Act, i.e. section 78. There is no authority, no statute cited by my learned friend to suggest that that rule extends across the Consumer Credit Act or anywhere else. So where we have that section 78 point in Carey, you can reconstitute it from different sources simply because the regulations allow you to remove things from the agreement, like the signature box and and matters like that. So in terms of Carey, that's the authority that section 78 allows for a reconstituted document because of the reasons set out in Carey. But there's no authority that can be extended beyond that.
Well, as Mr. Jones said, there's no authority either way, or we probably wouldn't be here.
My lords, I've set out as clearly as I can in my skeleton argument as to why, so I won't revisit that. My second point is my learned friend referred to the no issues being raised as to prescribed form before the judge, Deputy District Judge Simpson. The paragraph referred to is the core bundle, tab 9, page 60, and it's paragraph 23, where that is actually said, where the Deputy District Judge said, I have had no issues raised today in relation to the prescribed form of the notice. And I'll just draw your lordships and your ladyships' attention to paragraph 23 of the transcript, which you've already had sent up this morning.
Page 23?
23 of the transcript, which was sent up this morning. And about halfway down the page, there's a paragraph that starts with my submissions. Now, there is no inaudible in parentheses.
Yes.
Now, I think what the district judge is saying in his paragraph 23 is about the formal compliance of the reconstruction with the regulations. I'm not saying that if that was the form of document sent, then it's deficient. I think that's his point. You clearly you made the point that is partly recorded in the transcript on page 23.
Yes.
because you're comparing the list of numbers with what has to be done.
Precisely, we didn't have.
It's a different comparison, I think.
Precisely, we didn't have a document with which we didn't have a copy with which to make submissions about its non-compliance because there wasn't a copy, as Her Honour Judge Clarke found. So how can we make comparisons for a document we don't have?
Yeah.
And that brings me on to my final point in reply, is the rule before the court is whether a judge can rule that a notice is compliant and contains specific wording without ever seeing that wording. And my submission is, it is not open to a judge to infer a cause of action or any such compliance.
Sorry, could you just repeat that? Because I want to make a careful note of what you said.
Yes.
But the question is whether
The real
can
question
rule
is,
that a document-
can a judge say that a notice is compliant and contains specific wording without ever seeing that document or without seeing that notice? Judge, is this compliant? What is it you're holding? Nothing. And despite my learned friend's submissions that nothing will happen as a result of an upholding of the appeal below, I beg to differ. I think exactly what I've suggested will happen, that claimants will no longer produce the primary evidence which they're supposed to produce, either because they have not managed to keep a record or it's non-compliant, and then try to sneak in or rely on, I do apologise, rely on secondary evidence which doesn't pass the threshold test, balance of probabilities and evidence.
That puts it in a nutshell, really.
Precisely.
Yes.
Unless I can assist further,
Thank you.
those are my submissions.
You've both been very helpful. Thank you very much. It's an important point, and we won't try to give it the answer this afternoon. We will send out a draft judgment in the usual way, not for re-argument, but for typos and factual errors and so on, and submissions as to costs and so forth. Thank you very much.
Trying to take too much equipment with one go.
Please don't.